Good afternoon, Provost Davis, Professor Miller, faculty, staff, and students of the University of Oregon. I welcome you to this very special event. I have this time four very pleasant things to do. The first is to introduce today's featured speaker, and I'll do that here in a minute. And then I need to say a few words about the occasion that brings us to this and all the work that has been going on in our student body to make this happen. We'll invite Professor Miller to make some remarks, and our university provost has a role in this. Let me start with the introduction of today's featured speaker. There is a saying that success has many parents and failure is an orphan, and if that is true, then there are many who would claim to be Professor Miller's professional parent. Minnesota and Michigan and Harvard and NYU, and every one of the tables out there in the Commons, it turns out Professor Miller had a role in playing with Barbary and Westlaw and Lexis, and there are many who claim him from a parental role. I don't know of a saying about success's offspring, but if there were something about who could claim success's offspring, I think the University of Oregon would be in enormously good running for that competition. As many of you know, Professor Miller has been a law professor for some years and has taught at a number of OK law schools, some of which were attended by some of our faculty, and some of us even took courses from Professor Miller. Professor Gassama was one of Professor Miller's students, and Professor Hildreth was one of Professor Miller's students, and Professor Mooney was one of Professor Miller's students, and Professor Weiner was one of Professor Miller's students. Professor McKinley was one of Professor Miller's students. Professor Reynolds was one of Professor Miller's students, and I was one of Professor Miller's students. Even accounting for the admitted and potentially troublesome overrepresentation of certain law schools on law faculties, that is statistically just about impossible to imagine that many faculty members coming from a single professor. It's possible largely only because we're talking about Arthur Miller. I want to take a couple of minutes to thank, in particular, our student editors of the Oregon Law Review. I hope that you know how enormously proud we are of you. You have put on a first-rate symposium. The volume you produced is simply breathtaking. Its authors are a who's who on these topics, and with the possible exception of my contribution, they are first-rate pieces of scholarship. For those of you who have not read, my article at least has the benefit of being clear about its thesis in its title. The title of my law review article, which I expect to have many citations, is Arthur Miller Scared the Hell Out of Me. And it is a reflection of my experiences of him from a student perspective. We will momentarily be asking Professor Miller to share some remarks on the topic of his choosing, and as befits his scholarly history and practice, what he has chosen as the title is a question. Are they closing the courthouse doors? And like many of the questions he has been asking for now decades, it is deceptively simple sounding, vaguely important sounding, and you really hope he won't call on you to answer it. Before we invite him to the podium to make his remarks and to deliver his thoughts on this, I would invite University of Oregon Provost Lorraine Davis to the podium to help invite all of us to celebrate a very special occasion, not just for the law school, but for our entire university. So Lorraine.
Thank you, Michael, and thank you all for being here. I'm delighted to award this medal to Professor Arthur R. Miller. The medal was authorized last year by former President Richard LaRiviere and ratified with enthusiasm by interim President Robert Bradall, who regrets that he couldn't be here today. The Presidential Medal was established in 1991 to honor individuals who have demonstrated extraordinary service to the university and whose professional and personal leadership in the world community places them among the nation's foremost citizens. The medal is the highest honor that can be bestowed by the President of the University of Oregon. It is therefore with great respect and esteem that we confer this high distinction on our distinguished guest, Professor Arthur Miller. So if I could ask him to come forward, please. I'm going to make him stand here while I talk about him. Professor Miller is one of the nation's most distinguished scholars, if not the most distinguished scholar in American civil procedure, in addition to civil litigation, copyright, unfair competition, and privacy. As you've heard, he taught at the University of Minnesota, the University of Michigan, and was the Bruce Bromley Professor at the Harvard Law School for more than 30 years. He now is a university professor, the highest academic professorship at New York University. In addition to his esteemed scholarly career, Professor Miller has maintained a vigorous legal practice, arguing cases in all of the U.S. Circuit Courts of Appeals and before the U.S. Supreme Court. Professor Miller was the very first person to make law compelling television. Years ago, at a lecture at the University of Oregon, I had the privilege of introducing Fred Friendly, former CBS News president and grandson of Sampson Friendly, the namesake for our U of O's Friendly Hall. And he, in that address that he made, he commented on Professor Miller's body of work. Professor Miller hosted several weekly legal issues television programs. He was one of the earliest legal reporters on television with star power, serving for 2 decades on ABC's Good Morning America as an on-air legal editor. He won an Emmy for a PBS special on the Constitution. That was the Fred Friendly connection, if I remember correctly. In 1979, his weekly TV show, Miller's Court, was the first American TV show dedicated to the exploration of legal issues. In all areas of his work, scholarship, practice, and the media, Professor Miller worked tirelessly to promote access to justice and the public interest. Many Oregon law students plan on pursuing careers involving high-stakes political interest and public interest challenges, from tackling complex environmental disputes to vindicating consumer rights. But very importantly, they will bring human characteristics and importance to the law, and Miller's work informs them in that regard. For these future lawyers, Professor Miller co-authored multi-volume series, Federal Practice and Procedure, and that is an essential reference and has made possible many of the legal tools and strategies that they will use, or you will use, to address these kinds of problems. This work serves as an influence on students and what they do, and more importantly, how they do it. He has been appropriately acknowledged with 6 honorary doctorates, 3 American Bar Association Gavel Awards, and an award from the Queen of England. Professor Miller, your friends at Oregon honor your remarkable contributions to law and public service. In addition to the contributions on a scholarly basis, mention is often made of your profound impact on people, life-changing inspiration. We hope that this medal will serve as a reminder both of our high regard and of fond memories of your association with the University of Oregon. Thank you. Congratulations. The podium is yours.
Provost, Dean, students, far as I can tell, I'm now wearing this medal for service to the University of Oregon. But again, as far as I can tell, the only service I've performed for the University of Oregon is that in some metaphysical way, I've given birth to a number of the members of the law faculty. So I am having this out-of-body sensation that I'm sort of like the Octomom. It is a delight to be here. It is a delight to know that members of this faculty did survive my class, that one of them is now your dean. The president of my university, John Sexton, also was my student. And I've always felt that it's the ultimately demeaning thing to work for one of your former students. So now I'm surrounded by my president and your dean and the other people in the room who, and I say it specifically, survived civil procedure or some other course with me. From my perspective, academics don't get paid very much. What you really get paid in are your students. You have this sense of the students living on beyond you and possibly carrying some spark that you might have offered them. And that's been my life for many, many years, whether it is the Chief Justice of the United States, who was my student, or Barney Frank, or a defrocked governor of New York, or Jim Mooney, who's, he sassed me in 1965. And look at him, he still has that S-eating grin on his face. All right, to be serious, it really is difficult for me to realize that federal procedure and the federal courts have been the centerpiece of my life for more than half a century. And virtually everything I've done professionally, in some sense, relates to the federal courts. And throughout this half century, I have always believed in the purposes of the federal rules of civil procedure. And those of you who have taken procedure know it's all set out there in Rule 1, where it says quite simply and tersely that the rules are designed to seek the just, speedy, and inexpensive determination of every action or proceeding. Now, the people who wrote those words believed in citizen access to the courts and in resolving disputes on their merits, not by tricks or traps or obfuscation. So they wrote a simple system, a plainly worded simple system. The plaintiff only had to say where it hurt and what he wanted, sort of like Oliver Twist in the Dickens novel, when he asks for more gruel, please. This simplified pleading was followed by wide open discovery, equal access to all relevant facts. And again, this wide-angle discovery was that cases could be determined based on the revealed facts, not in terms of who was better at hiding the ball. That was followed by a summary judgment motion, but that was rarely granted. Only when the judge literally could say, I can decide this as a matter of law. There's no dispute as to the facts. And all this led to what I think of as the gold standard of Anglo-American civil justice, trial. And when appropriate, that meant trial before a jury. To me, it's all very American. Trying a case in an adversarial contest on a level litigation field. It's like apple pie and the flag and baseball. So, fool that I am, I devoted my life to it. And that was the conception in 1938. And for many years, that was the vision of civil justice pursued by the bench, the bar, and taught in American law schools. But, as is true of everything, our system has changed dramatically, along with culture and society. Back then, the typical lawsuit had one plaintiff, one defendant, and they would joust about simple issues, the kind of issues you get on a first-year law school exam. But today, litigation is beset by complexity, multi-party, multi-claim, multi-district, technology, communications, economics, arcane stuff. We have globalized commerce and communication. And the courts have been under pressure to modify that nice, simple system of 1938. Increased caseloads, protraction of lawsuits, the emergence of judicial management, which tends these days to trump a judge's time. Judges spend far less time in adjudication than they spend in management. It's all because the technological and sociological revolutions that followed World War II has transformed the business of our courts. If you thought about the workload in 38, what was involved? A little antitrust, a touch of patents, a bit of interstate commerce, a big junk pile of diversity cases, and that was it. It may be hard for you to roll back your minds to 1938. Indeed, it would be biologically impossible. But let me remind you that in 1938, the securities laws had just been enacted. The civil rights revolution was more than 2 decades away. Neuralgic statutes like ERISA and RICO and the abominable Patriot Act had not been enacted. But today we have civil rights, we have employment rights, environmental rights, consumer rights, product safety litigation. None of this existed in 1938. It may be hard for you to realize that, but none of that existed in 1938. Indeed, it did not exist when I was in law school in the 1950s. There were no courses on those subjects. It was a nice, quiet world of library books, fountain pens, manual typewriters, and something most of you have never heard of, carbon paper. Sadly, throughout the years since the 30s to now, law has become a business as much, if not more than, a profession. And sadly, that's what you will have to realize and face when you leave this school. It's highly competitive, it's territorial. Lawyers on both sides of the V, sometimes on the same side of the V, they troll for clients and play turf games. There's so much money on the table in some cases, it promotes unprofessional motivations and behaviors. The mega law firms, some now global, they're partnerships in name only. The Supreme Court has validated lawyer advertising, and in many parts of the country, that has converted practitioners into TV pitchmen. Law firm marketing, wining, dining, posh resorts, networking, marketing, brochures, the haggling, first on the plaintiff's side, for position in litigation, sometimes makes you feel as if you're in the Grand Bazaar in Istanbul. And on the defense side, the division of litigation spoils is more genteel and less visible, but it's there. It's not in the bazaar, it's on the golf course. Now, for a more positive note, before you all turn to medicine. Because of the tremendous quest for social equality and justice that followed World War II, we have two bars that did not exist when the rules were written: the public interest bar and the social action bar. Much wonderful and creative legal work has been done by lawyers pursuing the private enforcement of public policy. Indeed, we sometimes call them private attorneys general. Many of these people are purely altruistic. Some are entrepreneurial. Some are a mixture of the two. Their efforts go well beyond your classic civil rights and reapportionment battles. Asbestos. Asbestos was held accountable by the private bar. Tobacco has, to a degree, been cabined by the private bar. Defective pharmaceuticals such as Vioxx and diet drugs have been removed from our midst, and illicit financial and market practices of companies such as Enron have been halted by the private bar. Today, attempts are underway to hold those responsible for the recent financial crisis accountable, led by the private bar. And so some Americans don't die each year or become incapacitated each year as a result of defective products. And important social and economic policies are enforced because of what these lawyers do. Their work product speaks for itself. These private attorneys general can bring civil actions under laws relating to antitrust, securities, consumer protection, civil rights, employment discrimination, the disabled, and now my personal favorite, age discrimination. Sadly, a backlash has set in against the private enforcement of public policy. Special interests vilify the plaintiff's bar as a bunch of fee-hawking ambulance chasers. Americans have been defamed as litigious fortune hunters. Bogus statistics are propagated and fears are spread by claims that there is a litigation explosion. The statistics prove otherwise. And that Americans pay a litigation tax and our businesses are no longer competitive in the marketplace. Politicians make merry with their attacks on our justice system, cloaking themselves frequently in the mantle of tort reform and urban legends about certain cases, and sometimes imagined cases, abound, typically in highly distorted form. The so-called McDonald's coffee cup case has been grotesquely misdescribed, and with the aid of simplistic media accounts, has become a cosmic anecdote. The real story can be found in the HBO documentary Hot Coffee, recently aired, the producer of which will be in our symposium tomorrow. Now, all of this is given traction by the Supreme Court. It seems to have a thumb on the justice scale favoring defendants, and that has had significant consequences for citizen access. On one side of the ledger, they have narrowed the substantive rights under statutes like the securities laws. They're about to do it, I think, under the Alien Tort Claims Act, the backbone of human rights in this country. And this change in legal doctrine, this narrowing of substantive rights, has been accompanied by a transformation of the way we are now processing cases in the federal courts. I've grown increasingly concerned about the earlier and earlier disposition of litigation. The earlier you dispose of cases, the less meaningful is the right to a day in court, and you indirectly eviscerate the underlying substantive rights and deny people a meaningful hearing on their grievance. Remember the image I suggested before: trial before a jury. Today, there are hardly any trials. There are hardly any trials in the federal courts. Indeed, a popular subject for discussion in the bar is dubbed the vanishing trial. There are many reasons why the trial, as that gold standard, has turned to dross. A significant reason is you never get to trial because you're terminated before trial. This began about 25 years ago when the Supreme Court of the United States decided 3 summary judgment cases in the same term. You probably studied one or more of those cases. The court invigorated the summary judgment motion. That sleepy little motion of 1938 became the amoeba that ate New York in 1986. Courts resonating to the Supreme Court's 3 decisions started to grant summary judgments more frequently. Well, that's like holding a candle or a carrot in front of the defense bar. If the court's going to grant the motion, let's make the motion. And what has developed is not trial, but a summary judgment-centered litigation system. Summary judgment, in other words, has been like a gigantic stop sign, shielding people from that trial. In '93, the Supreme Court did it again, this time in the name of judicial gatekeeping. In a case some of you may have studied, Daubert versus Merrill Dow Pharmaceuticals, they said any economic, scientific, technical evidence has to be screened for scientific viability. Pharmacology, technology, whatever it is. Now, modern litigation turns in significant part on expert testimony. The plaintiff cannot survive without expert testimony. This plays into the hands of the billing by the hour defense bar. It's another toy. It's another stop sign. It works in a diametrically supposed way on the plaintiff's side, because those lawyers are typically under-resourced and working on a contingent fee basis. Whatever it is, it's another procedure, another stopping point, another motion, another hearing, another potential ground for appeal. And if you cut the plaintiff's expert out, the chances are the plaintiff's case cannot proceed in terms of economics or viability. More recently, the court has busied itself with the class action and made the class action certification motion another stopping point. It has consistently upped the formalistic interpretation of Federal Rule 23, making it harder and harder to seek and achieve class certification. Case I'm sure most of you read about, studied, Walmart. Past year. Heighten the barrier. What must the plaintiff show on a certification motion? Significant proof of employment discrimination. If you can't do it, the case isn't certified. If the case isn't certified, the economics of litigation make it impossible on the plaintiff's side, working on a contingent fee, to pursue the rights of any particular individual. The economics just are not there. The certification motion, like the summary judgment motion, like the Daubert hearing, has simply upped the cost and the delay and the risks of pretrial termination. And in parallel to Walmart, in a case that the more I think about it, the more upset I get with it, AT&T Mobility versus Concepcion. You rent a car, you sign a lease, you get a credit card, you open a brokerage account, you sign up for a mobility phone, an AT&T or somebody else's mobility phone. And embedded in that contract you sign without reading, and don't tell me you do, because you don't, inside that contract is an arbitration clause. And in the Concepcion case, the Supreme Court basically said, you cannot proceed in arbitration on a class basis. And once again, what effective relief is there for the person who leases the phone for $40 a month or what have you to litigate on his or her own against AT&T in arbitration? It can't be done. These are people without bargaining power. They're offered a contract on a take-it-or-leave-it basis. It's boilerplate. It's boilerplate arbitration that trumps access to the public dispute resolution system. And that's true even if you can show the contract is unconscionable, because the arbitration provision trumps. Compelled arbitration replacing courts and process transparency. Well, as we move back in litigation time, we now come to the pleadings. And you all know about two cases decided by the Supreme Court just a few years ago. Bell Atlantic versus Twombly and Ashcroft versus Iqbal. These two cases, simply put, turned their back on over 60 years of federal pleading jurisprudence, with an effect so dramatic that cartoons have appeared which depict a lawyer consoling a despondent client and telling the client, we've just been Twombly'd in the Igballs. I'm an old fogey. I think nostalgically about what the hell the pleading rule actually says. A short and plain statement showing that the pleader is entitled to relief. For the first time in 60-odd years, somebody paid attention to the word showing and used it as a fulcrum to saying showing means more than notice. No one had ever thought about that in 60 years. And the court says, no, you've got to have facts showing plausibility of the claim. Gave no guidance other than saying plausible means something more than purely speculative or possible, but less than probable. That's a big help. It's got to be bigger than a bread box, but not as big as a refrigerator. Court was more specific in Iqbal, saying plausible means a reasonable possibility of relief. Vague words. Well, how is a judge supposed to figure that out based on the complaint? Answer from Justice Kennedy. You realize, if you watch the healthcare debate before the court, or heard it, there's only one justice on the Supreme Court. His name is Kennedy. And he seems to be the villain of the piece, because here's Kennedy writing in Iqbal. And he says, judges are supposed to use judicial experience and common sense. Now think about that. It must mean a newly appointed federal judge has no experience to think about. And I'm supposed to believe that common sense is equally and generously bestowed on each and every federal judge in the United States on an absolutely equal basis. What it sounds like, once they throw in a third element, that a judge is supposed to consider possible innocent explanations for the defendant's conduct. It's all an invitation to evaluate the case's merits based on a single document. No discovery, no trial, not even a scent of a jury. It simply appeals to judicial subjectivity. Now, you've all taken civil procedure. You know that when you write a complaint, you don't put in paragraphs about judicial experience or common sense. And unless you are the world's most fanatical masochist, you don't sit there writing innocent explanations for your opponent's conduct. It's not in the complaint. Yet, it's only the complaint that the court is supposed to consider on a motion to dismiss. I don't care what system of procedure you're thinking about, our federal rule system, any state variation on the federal rules or the codes, or let's go back to the good old days of the common law. The motion to dismiss asked a very simple question, and only one question. Does this piece of paper state something the law recognizes as a grievance? For example, I sue Professor Reynolds. Going back to the days she sat in my class, I said, she gave me a dirty look. She gave me a dirty look in class. Now, even without the marvelous procedure education she did get, she then moves to dismiss, right? Does her motion to dismiss turn on whether, in fact, She did give me a dirty look? No. Whether I've been injured by the dirty look? No. The only thing the judge is supposed to do is A, accept the facts as pleaded, B, bend over backwards in the pleader's favor, and C, ask whether the governing tort law recognizes a dirty look tort. If it doesn't, I'm dead. If, curiously, the substantive law does recognize it as a form of emotional injury, motion to dismiss denied. But now, with Twombly-Iqbal, what's happened is that motion to dismiss, that narrow gauge motion to dismiss, has been morphed into a summary judgment motion without the benefit of discovery or elaboration, terminating cases at their very beginning. Totally ignored by the court in both cases is the obvious problem of information asymmetry. Now, we don't live in a world in which everyone has equal access to relevant information. This is not an agrarian society in which a buyer can look at a farm implement or at a horse and say whether or not it is a defective product or not, and make a judgment accordingly. We live in a world in which buyers of cars may not understand anything about internal combustion engines. When you pop a pill, do you do a chemical analysis of it? Can you do a chemical analysis of it? Do you know the research and development that led to the pill? Of course not. It's complete information asymmetry. That's what discovery was supposed to solve. But not under Twombly-Iqbal, because the court says no discovery unless you have first shown a plausible case. So where are we? The court has moved the system from a notice pleading structure, which is what they intended in 1938, to a fact pleading structure, which is exactly what the people who drafted those rules specifically rejected. Not only is it a problem of how can I make the motion to dismiss grade, but now you have created a pleading structure that creates disincentives from bringing cases. So even when a plaintiff's claim may have merit, may have plausibility, it may not be initiated because the risk of losing without any prospect of compensation is too great. Not surprisingly, as we learned in the 80s and 90s with the summary judgment enhancement, motions to dismiss based on the pleadings have gone through the roof. Everybody does it. More motions, more hearings, more dismissals, more appeals, and more premature terminations. Now, just a few months ago, the court turned the termination clock back even further, or at least, to be accurate, 4 justices tried to. Some of you studied it this fall, the McIntyre case, McIntyre versus Nicastro. The justices divided 4 to 2 to 3, which for you baseball fans is a very odd double play combination. But there it is. It's about the constitutional limits on jurisdictional power over defendants who aren't in the forum and may not have acted directly in there. Now, just in case some of you are beginning to slumber, I give you all a touch of shock therapy and remind you that you all studied a 65-year-old case by the name of International Shoe Corp versus State of Washington. And remember how that created new doctrine about personal jurisdiction under the 14th Amendment. Well, these four justices would love to turn their back on that. They would love to constrain notions of minimum contacts equaling fair play and substantial justice. It's not enough for these four justices that the defendants have contacts with the forum. Now, who wrote the plurality opinion? Who wrote the plurality opinion? It's that guy Kennedy again. He says the defendant must have targeted the forum, must have intended to submit to the jurisdiction of the forum. Ever meet anybody who said, "Hi, I intended to submit to the jurisdiction of that forum"? Took us back to days of sovereignty, took us back to that other hateful case you studied, Pennoyer and Neff. That's all right. That was in the 1870s. Going to wipe out Shoe. Might as well go back to Pennoyer. The result, if the plurality has its way, is that injured consumers or employees won't be able to sue for defective products or services where they live, where they were injured, where they acquired the product or the services. They'll have to move to a distant forum, because all the defendant has to do is establish a distribution system that targets no American jurisdiction or targets one American jurisdiction, as in Nicastro, it was Ohio, even though the products are known to be distributed to other American districts. 3 dissents, guess who? Guess who? Sotomayor, Kagan, and Ginsburg. I happened to be with Sotomayor the other day. All us New Yorkers hang out together. And I told her, I never thought I would see the day, an old fogey like me, that I really wished there were 9 women on the Supreme Court. So there it is. Yet another potential, because it's only 4 votes, the 2 concurrences, Breyer and Alito, a weird combination. They didn't buy into the Kennedy writing, they just agreed with the result. So it's going to take another case and another case to figure it out. But it may be another stop sign. It may be one at the genesis of the case, jurisdiction. It certainly incentivizes defendants to move to dismiss for lack of jurisdiction. So when you take a panoramic view of what's happened in the last 25 years on the procedure side, and you couple it with the great growth in front-end defenses, preemption, immunity, exhaustion of administrative remedies, time limitations, and add to that that virtually every amendment to the federal rules have constrained discovery since 1983. There's no secret about what's happening, why, and who benefits. I like sports metaphors. This all feels like judicial piling on, and it goes on and on. The effect of these procedures and their shift is seismic. Again, We used to have a commitment to trial and jury trial, all in public view. Then we had an increased invocation and granting of summary judgment, destroying the possibility of trial. Now we have a potential dispositive pleading motion coming even earlier based on one piece of paper, the complaint. Now we have the McIntyre plurality with a heightened possibility of dismissal for lack of jurisdiction. Someone who's cynical, not me, but someone who's cynical might say, what's next? How about posting a sign on the courthouse door saying closed? Not only is all this happening earlier in the litigation, it's based on less and less information. Stop and think about that. We're making decisions based on less and less information. A trial provides live evidence, examination, cross-examination, and often jury deliberation. Even summary judgment is based on discovery productivity. Again, the motion to dismiss is based on just the complaint. No discovery, no evidence, no witnesses, no cross-examination, no voice of the community. This isn't a system I know anything about. It's time for me to go to the pasture, I guess. Simply put, the court has given primacy to efficiency and systemic cost. They've offered three explanations. If you read Twombly-Iqbal in particular, they talk about the threat of abusive litigation behavior and frivolous lawsuits. Second, they say litigation's expensive. And third, they say extortionate settlements against economic entities must be avoided. Okay, it reads well. What the hell's the truth? Do they cite any anything? No. What's the truth? Well, I'll be autobiographical. As Yogi Berra, that great baseball philosopher, would say, these bleats by the court, it's deja vu all over again. I was the reporter to the Civil Committee in the 70s and 80s. And our committee decided to focus on cost and delay. Chief Justice Burger was ranting and raving about it. And the place you deal with cost and delay is in the pre-trial process. That's where cost and delay reside. And the defense bar, this is in the 70s, was making a lot of noise about abuse, frivolous litigation, cost reduction. I was young, I was naive. I figured I better find out about abuse and frivolity. So I spent close to 6 months going to Bar Association meetings and judicial conferences, asking people, tell me about abuse and frivolousness. I wanted to help the committee with some intelligent rule revision. I listened. At times I felt like Diogenes with a lamp searching for the truth about abuse and frivolity. Well, after 6 months, I was confident. I went back to the committee, told them I had learned a great deal. I could tell them with considerable confidence that according to the practicing bar, frivolous litigation is any case brought against your client. And abuse is anything the opposing lawyer is doing. Now it's 30 years later. I'm no longer young. And I sure as hell am not naive. I can't do any better. You know why? We've never defined abuse and frivolousness. We've never measured it. We don't have a clue who's guilty of it. Yes, there are cases most would agree should not have been brought. There are motions and discovery requests and discovery objections most would agree should not be made. How many? We don't know. Most assertions of frivolousness and abuse are completely subjective. They lie in the eyes of the beholder. Despite the absence of any real knowledge, these abstractions seem to motivate the Supreme Court of the United States and many other courts. Now, what about extortionate settlements? How many times do they occur? Again, we don't know. We don't know. We don't even know what an extortionate settlement is. We don't know how to recognize one. We don't have benchmarks. Some settling defendants proclaim, oh, we were extorted. How do we know that? Cases are settled for a myriad of reasons, human reasons, most having nothing to do with the merits or demerits of the case. They're settled for business reasons, for regulatory reasons, for public perception reasons, desire to clear a contingent liability off the books, or simply a lack of resources to continue to litigate. For you baseball fans, someone here has got to be a Mets fan. No, nobody has to be a Mets fan. It's not in the Constitution. But you all know about this big fight between the bankruptcy trustee in Madoff and his attempt to get $1 billion out of the owners of the Mets. And they settled for $300 million. Was that extortionate? Was that extortionate? If Fred Wilpon really thought he was not in Madoff's pocket, why would he settle? I don't know, maybe because he had to wipe that contingent liability off his books to borrow more money to put 9 people on Citi Field turf to play for the Mets. We don't know. We don't have a clue about extortionate settlements, but we sure as hell hear a lot of noise about them. And costs? What about costs? Nobody likes them. Anybody like a cost? You like paying tuition here? Nah. Again, we don't know very much. We really don't. We measure defense costs, but that's it. Again, it's impressionistic. The statistics, the empiric data suggests they're much less than people think they are. That the high-cost cases are that narrow band of big federal cases. Much less of a problem than we've thought. Well, the judiciary has switched from an easy access to a pro-defense point of view. Current court seems business-oriented or anti-litigation oriented. We seem to have lost the direction of the federal rules. And the time may have come to think about resurrecting what it is we're trying to do in civil litigation. There are a myriad of possibilities other than putting up stop signs. And our profession owes it to the larger community to use its inventive skills and employ them to that end of somehow revitalizing this system. Our aspirations should be those that our founders embedded in the Constitution, in the Fifth Amendment, day in court, Seventh Amendment, jury trial. 14th Amendment, due process. Our aspirations should be those that committed us to the rule of law. Our aspirations should be those that motivated engraving equal justice under law on the front of the Supreme Court. They should not be to obstruct citizen access to the justice system by constructing a procedural wall around the courthouses. And that's where I'm afraid we seem to be headed. But I don't feel strongly about